Back. Right. I'm Dave Cunningham. I'm the Dean of Workforce Training here, and Larry asked me to introduce our speaker tonight, who comes from Northern Ireland. Northern Ireland, I'm also from Scotland, which is also part of the Celtic part of the world, and our roots are Celtic, and Gaelic would be the language of the Celts. Scottish Gaelic and Irish Gaelic and Welsh Gaelic are a bit different, but the roots are the same. Anyway, it's my honour to introduce Dr. Caoimhin McMullen, who's going to be speaking tonight. But let me just give you a few housekeeping points before we go any further that Larry's given me to share with you. In your packet, there are question cards. So if you have a question that comes up during the lecture, write it down on the card, and somebody will come around and collect them from you and bring them up here. There's also in your packet a feedback sheet. And what Larry would like at the end of this evening is for you to fill that out and share your notes on how we might run these evenings a bit differently or improve them in the future. And if you have a cell phone, and I've got one right here, if you have a cell phone here tonight, make sure you turn it off, okay? Because if you don't turn your cell phone off when you're in Ireland, believe me, there's big trouble. So don't make any mistakes getting the cell phones off. Now, let me introduce to you Dr. McWhalen is speaking tomorrow at an international conference on this subject of genetically modified food. And it's just very fortuitous that he's able to come tonight. And in talking with him this evening, he assures me the jet lag is really working on him. And he nearly fell asleep while I was talking to him. And that happens a lot. I notice when I'm talking to people, they just kind of fall asleep. But anyway, he really is suffering from the jet lag. And if you've crossed the Atlantic, you know what that's all about. It can really be really nasty. Anyway, in his speech tonight, he's not going to be representing the Irish government, and neither is he representing European government policies. It's purely his personal position on transgenic organisms. And if you probably are aware, in this state, in the fall of this year, there's going to be a public initiative on the whole topic of genetically modified food. And the initiative is if it's passed, will mean that any food products in this state that have been genetically modified or have genetically modified ingredients will be labeled. And that's the plan in the state of Washington. Anyway, his views this evening are born out of many years of studying and writing, and a listing of Dr. McWhalen's contributions is actually in your program, so you should have a copy of some of his research. So he's going to be speaking for about 40 minutes, and then the evening will be opened up for questions. Are there any questions here on what you're in for, and you feel like you've come to the right meeting? Anyway, so give a big hand here to welcome our speaker this evening. Thank you. And I have to apologize. My wife is ill, and I unfortunately have to leave. But let's give a big hand here to Dr. McWhalen. Yeah. Thank
you. Perfect. Okay, thank you.
Larry, is that okay?
Thanks very much, Dave, for the introduction. And thanks very much, Larry, for organising this evening and for having me along. Larry has promised that we'll go for a drink afterwards, which I'm very much looking forward to. I have 5 sons at home, aged between 2 years and 10, which means it's exactly 10 years since I last went out for a draft beer. So I'm very much looking forward to it. And my tolerance is very low now, so if we have a second, I'm in big trouble. I'm going to talk to you tonight about EU food law in more general terms, and I will mention the whole genetic modification thing as part of it. But I'm trying to focus on some of the current issues and give an overview of the way in which the regulation of food happens at EU level, and perhaps do some comparisons with what happens elsewhere and what sort of international influences bear down on EU law as well. Just to re-emphasize Dave's point, in my time at the moment, it's now 3:10 in the morning, so I apologize if I'm a little hazy at times or whatever. But I'm going to talk about food law, and at any stage, obviously, I'm talking to people who don't have perhaps an EU law background more generally. So if there's any of the terminology or anything that you need explained, please, I'm more than happy to stop at any stage and answer any queries or explain anything as we go along. Okay, just as by way of introduction, food laws have existed in the European Union and in other states for a long time, but there weren't very many of them. The earliest examples of law in general, things like the Code of Hammurabi, the ancient Babylonian tablets, made references to food, both in the way in which crimes could be committed and crimes could be paid for. And in Europe, more specifically then, in ancient Rome and in ancient Greece, systems developed for ensuring, for example, that wine was of a particular quality and that food remained as unadulterated as possible. This led through to the development of other laws in the Middle Ages, like, for example, the famous German beer purity laws, which were developed in 1516, which said you could only make beer using barley hops, yeast and water, and never any additives, nothing else. And they ended up being brought to court before the European Court of Justice because of this, because they were preventing other countries' beer from being sold on their market. We also had early laws in places like Britain, where we had things like the Assize of Bread and Ale, which was introduced in 1276. And the Assize of Bread and Ale set out certain requirements that meant that you had to match the price that you charged for bread and ale to exactly the same cost as your raw materials or ingredients. And the punishment for not complying with these laws could be the removal of a hand, which is actually how we've ended up with the phrase a baker's dozen, representing 13, because there was no baker who wasn't going to make sure that he didn't comply with the laws. When he was giving somebody 12 of something, he gave them an extra one to make sure he brought it over the minimum weight requirement and therefore retained both of his hands. So we had other legislation introduced as well in the 17th century, in the 18th century, things like the Adulteration of Tea and Coffee Act, which prohibited for the first time the reuse of tea by boiling it up in a mixture with sheep's dung, which actually it isn't that peculiar. In some countries in the world, boiled sheep's dung actually is still used as a tea substitute, and I'm informed that it's actually quite nice. But there were other rules as well in place, making sure that things like plaster of Paris weren't added to flour to give it more weight when they were making bread. So we had Tea and Coffee Acts, we had Bread Acts. But it's really only when European countries joined what was then called the European Economic Community that their laws started to develop. And the general premise we work on now is that almost all laws in all of the 27 EU member states come directly as a result of their EU membership, either by directives or by regulations, which are just forms of legislation which are introduced covering all sorts of different areas. And we're going to look at some of those areas tonight. But all laws now come from the EU. Now, in some ways, that can be a good thing because it means we get standardization, and sometimes that standardization can be quite high. So we've got good safety requirements, for example. But in other circumstances, it also prevents member states from taking action where they might want to. So, for example, and I'll be dealing with this a little bit later on, some member states have tried to take their own legislative initiatives to counter things like rising rates of obesity in the EU. But they're unable to do anything about this or to make it enforceable by the law in any way, because if they did, they would be acting contrary to European Union law. So unless EU law introduces the initiative, the individual member states can't do it themselves, and they're effectively prevented from dealing with certain health crises that they might be undergoing at the time in the way that they might want to. Okay, so almost all laws now come from the EU. And I'm going to use as my starting point, because it's a case that came before the European Court of Justice. And it's a very significant case because really almost everything that we've done since then has to be measured against what happened in this case. And the case is known as the Cassis case. Now, to give it its full title, this used to be one of my party pieces, it's Rue Zentrale AG against, and this is all one word, Bundesmono Pulver Waltung für Brandwein. I apologize to any Germans who might be in the audience. I'm sure that was way off the mark. but more easily called Cassis. And the reason it's called the Cassis case is because it relates to the fact that Germany had rules in place which said that you could only sell fruit liqueurs on the German market if they had a minimum alcohol content of 25%. French blackcurrant liqueur Cassis, which goes very nice with Crémant to make a Kir Royale, usually has an alcohol content of around 15 to 20%. So they couldn't sell their product on the German market. And the French Cassis producers argued that this was contrary to European Union law on the free movement of goods. They're being prevented from marketing their product in another member state. Germany puts forward two arguments to support its position. It says, first of all, we need to have a minimum alcohol content to protect consumers, and secondly, and perhaps more strangely, to protect health. Their argument was that if we have lower alcohol products on the market, people will consume more of them, they'll become more tolerant to alcohol, and therefore we'll have a problem with alcohol as a consequence of that. That argument obviously wasn't accepted by the court. On the consumer front, they put forward the argument, well, our consumers are used to purchasing fruit-based liqueurs with a higher alcohol content than this. But what the Court of Justice said there was, and this is really the important point, is that no, look, you can't put a requirement like that in place. Instead, you can just oblige that the labelling makes it clear to the consumer that this product contains 15, 18, 20% alcohol, whatever it happens to be. So labelling can be used to counter any of these consumer protection arguments. Now, the important point in relation to this is that it leads to the development of a legal principle known as the principle of mutual recognition. And this underpins really so much of what happens now in relation to the regulation of food in the European Union. And the principle of mutual recognition is that once a product is lawfully marketable in any member state, it has to be lawfully marketable in all of the member states. So Germany said at the time, well, this is going to lead to a race to the bottom. What if a member state has got no standards in place? That means nobody can have any standards in place. And certainly for a while, there were concerns that this was in fact the case. How can we have standards on anything? People could produce products with inferior, substitute ingredients, call them the same thing as the product that consumers were used to purchasing that had that name, and it leads to unequal competition and a lack of consumer protection because they're faced with two products, and price being such a key determinant in consumer decisions, well, they're going to go for the cheaper one rather than the other one. And that really put the producer of the quality product at a disadvantage. So we had this real problem now that you have this principle of mutual recognition, meaning that if it's marketable in one member state, it's marketable in all. Now, there are some exceptions to this rule, like, for example, if it is deemed to be necessary to protect health. But the Court of Justice has defined health very, very narrowly. It basically says health is only identifiable and immediate risk. So if something is poisonous or contaminated, well, that's acceptable, an acceptable health exception to this rule. However, if something's merely bad for you, that's not a health consideration at all. So if something is laced with trans fats, for example, that's not a health issue. You can't take action in that regard. So anything that's to do with nutrition, the court has determined has nothing to do with health. Okay? It's only things that are poisonous or contaminated in some way. Now, what's also important about the Cassis case is that the other European institutions, like the European Commission, says, well, if we've got the principle of mutual recognition, we don't need food standards anymore. Okay, we don't need to set compositional requirements for foods, saying you have to make them with these ingredients, in these quantities, in this particular way. And prior to this, they had developed a series of what were called the recipe laws. In particular in the early 1970s, before this decision in Cassis, which takes place in the late 1970s. So we had recipe laws, for example, for things like chocolate, honey, jams, coffee, chestnut puree. Just a very limited list of things. And chocolate actually proved to be particularly controversial and led to a 30-year political debate over what was and was not chocolate. In particular, at the same time as this directive was being introduced setting standards for chocolate, the UK, Ireland and Denmark were all becoming EU member states. And they tended to make chocolate with 20% cocoa, 20% milk solids. But in other EU member states, they tended to make it with a minimum of 25% and usually 30% cocoa. So there was all sorts of arguments. States like France and Belgium, who would be very proud of their chocolate production, said, no, you've got to call this milk chocolate with a high milk content, which obviously the UK and Irish producers weren't interested in this. So 30 years it took to resolve the issue, and in the end they said, okay, you can sell British and Irish chocolate on our market, but you've got to call it family milk chocolate. So that was the compromise that they ended up coming up with. But we had other standards as well for honeys and jams and things like that. But because of the decision in Cassis, they say, we don't need standards anymore. And as a result of this, a consequence of the decision to cease introducing minimum standards and this principle of mutual recognition, whereby if you could sell it in one member state, you could sell it in all member states, and you could call it the same name, whatever you liked. We have this overall argument that, well, this is leading to decreasing quality. So they do something to counter this. And they introduce a scheme for the registration of what we call geographical names. And this is quite a well-developed scheme now in the European Union. It's existed since 1992, and we've got two main types of geographical names: the protected designation of origin and the protected geographical indication. And the only difference between the two is that for the protected designation of origin, all parts of production, processing, packaging have to take place in the original region of production. With the protected geographical indication, it only has to be one part or more parts of the process. So not all parts have to take place there. But what are these designations of origin and geographical indications then? Well, they've actually led to quite a lot of debate, in particular at the international level within the World Trade Organization. Because, if an Italian producer has been making a product called Parma ham, and in Canada they're also marketing a product called Parma ham, well, the Italian says, our name is actually protected, your product's got nothing to do with Parma whatsoever, we would like you to stop using that particular name. And that's the type of name that's covered by the geographical names regulations. It's where you have a foodstuff which has a specific characteristic which is linked to its original place of production. So things like, and there's some examples at the bottom there, feta cheese, Parma ham, Gorgonzola cheese. These names can be applied for registration, and once they are registered, they're protected, and nobody else can use the name unless you satisfy the terms of what is called the product specification. That is all the details on the property of the food, the way in which it's been made, the place in which it's been made. You can't use the name. Now, there's a problem with this, however, in that under the terms of the regulation, you can't get your name registered if the name is deemed to be generic, right? So it has come into such common usage, it can't be registered. So the obvious or the best example of a generic name would be something like cheddar cheese. Okay, cheddar obviously is in Somerset in the southwest of England, but cheddar cheese is made all over the world. It's used to describe all sorts of different types of hard cheeses which have got nothing to do with cheddar whatsoever. So it can't be registered. And once a name is registered, it can never become generic because nobody can use it. So protected status is actually really important, and it has been shown to have huge economic benefits for those who've been able to avail of the scheme. It's also led to a series of interesting cases which have come before the European courts, most notably what's known as the feta cheese saga. And it's known as the feta cheese saga because it appeared before the court on several occasions. It involved several redraftings of the legislation, all because there was a lot of debate over whether or not feta was a generic name. Feta isn't the name of a place. It comes from the Italian word for slice. It was being produced in about 9 or 10 different EU member states, and it had been produced outside of Greece for a long time before Greece sought protection. So what we had was an initial registration of feta as a protected name. We then have 3 member states, Denmark, Germany and France, complaining about this. They bring the European Commission to court. They say you should never have registered this name. It's generic. And the court doesn't say it's generic, but what it does say is look, you should have taken the situation in other member states into account. You didn't look at what's been going on historically in other states. I mean, there was evidence, for example, that Greece hadn't even been applying its own laws on the production of feta. The Commission goes away, it does this big survey, it shows all sorts of things, like even Danish producers of feta were sticking pictures of women in Greek traditional costume on their product. So they're saying even Danish producers were trying to represent to the consumer that this was a Greek product or had some association with Greece. So they then re-register feta. It then comes before the court again when member states seem to have that registration annulled, and that's ultimately refused. But it made several appearances before the court and was involved in several pieces of legislation. And it's certainly debatable as to whether or not feta is a generic name. In particular, there was lots of evidence produced before the court, which it used, possibly for political reasons, to show that feta was generic, when actually it probably really represented that feta was not. But some other interesting cases show just how far these regulations can extend. In relation to Parma ham, for example, which is also a registered protected designation of origin, this came before the Court of Justice when Asda supermarkets in the UK were importing Parma ham from Italy. There was no problem with that. But then they were slicing it in the supermarket. And this was complained about before the European Court of Justice. They say, no, even the slicing and the packaging needs to take place in the Parma region for this to be acceptable for use of the protected designation status. And the court agreed with them. The court said, yeah, no, it's not good enough to just have the meat produced, processed, everything there. It must also be sliced and packaged on the premises. And in relation to gorgonzola, we can see as well just how far this extends. There's something within the regulation. You get a big degree of protection and if you get your name registered. And that includes protection against something called evocation. And evocation means you don't use the same name, but you use a similar name to describe a similar product. And the problem here was we had Austrian producers making a cheese called Cambozola. And the Gorgonzola producers go to the court and say this is an evocation of the name Gorgonzola, and the court again agrees. It says it's describing a similar product, a similar type of cheese, and 2 out of the 4 syllables are the same. Therefore, yes, there is potentially a problem with this, and this could potentially be evocation. So on the one hand, we have our decision in Cassis and the development of the principle of mutual recognition, which unarguably leads to depreciating quality standards and the least level of protection afforded to consumers. And on the other hand then, we have situations like this geographical names regulation, which extends this huge level of protection to the names which are registered under the system. And it's certainly arguable that it goes far too far in this regard. What's interesting, I just want to put this up at this stage because it relates to a point that I'm making later, is that since 2010, if you have this protected status, you have to put this on your package. And pre-2010 and pre the introduction of this symbol, I mean, the symbol always existed, but you never had to use it. Very few people knew anything about protected designations of origin or geographical indications. But since this has appeared, there's a lot of evidence to show that there's increased consumer recognition of the symbol and what it represents. And now people at least are able to say, okay, we've got 2 different types of ham here or 2 different types of olive oil. One of them carries the symbol and one doesn't. Without knowing anything else about the products, I can see why perhaps there is a premium for product B. It has been made in a traditional way to minimum standards without artificial substitutes, etc. So the increased use of this symbol has definitely led to an increased awareness and economic benefits for the producers as a result, because it does designate something to do with quality and tradition. In relation to food labelling more generally, I just want to talk about this for a minute because it brings me on to another point. Sorry, I always drink a lot of water during these things. I get very parched during it. Every year in Trinity College in Dublin, they do this staff-student cabaret, and when they're mocking me in it, they bring in one of those big 5-litre things of water from the water cooler and put it down in front of them. But anyway, looking at these broader labelling requirements, just to give you a brief outline of what requirements exist in EU law at present, and the main reason I introduce this at this stage is because one of the most significant changes to our laws has taken place in this area at the end of 2011, but which will come into effect between 2014 and 2016. We have, first of all, framework legislation going back to 1979. Okay, we had a directive introduced which set harmonized labeling standards for all prepackaged food products. So it set out a list of requirements that had to appear on all food products. So things like the name, the quantity of the product, the seller's details, the best before date, all of that type of information. Origin details, but only in some circumstances, and that's another point. So we had this framework legislation introduced in 1979. It gets replaced in 2000. Just a few minor changes made, things like quantitative ingredient declarations, whereby if you make a representation on the product that it contains a certain ingredient, you must say what percentage of that ingredient is in the product. So you have a bar and there's strawberries in it, and you've got a picture of fresh strawberries on the front. You've got to put in the ingredients list strawberries, usually something like 0.5%. Okay. We then also have a directive on nutrition labelling, introduced in 1990. And prior to this nutrition labelling directive, there were no nutrition labelling requirements in the EU at all. Some member states may have had some things, but not much. And what's interesting about this, and this is still the case today, you're not obliged to ever put nutrition labelling on a prepackaged food product in the EU, unless you make some sort of nutrition claim about the product or health claim about the product. So unlike the US, nutrition labelling is not compulsory, okay? It's only compulsory where you make a claim, where you actually say this product is good for you for some particular reason. We did have another piece of legislation then introduced in 2006 on nutrition and health claims. And in particular, what we were starting to see was, prior to this, consumers were being charged a premium for products that were making claims about themselves, that they were good for you in a particular way. And all this was happening in the context of a clear identification of increased consumer interest in the link between diet and health. Now, as you're probably familiar, in the 1990s, we had a huge food-related crisis in the European Union in relation to BSE. And post-BSE, there was an awful lot of emphasis on safety, health, linking health and food. People have become a bit frightened and a bit scared about what was going on in relation to food, as they were as well around 2000, 2001 in relation to genetic modification. But I'll come back to that in a minute. So we had this nutrition and health claims regulation introduced, obliging producers to scientifically verify, first of all, that their product contained something useful, and secondly then, that this useful thing actually had a benefit. And it would have the benefit if you consumed the product in reasonable quantities. I always remember in particular doing an investigation into this product which was selling itself. It was a water product. It was water basically. And it was selling itself as being rich in calcium. And they had this picture of children with all these damaged bones, and they drank about a mouthful of the water and all their bones were healed and they were great. If you consumed 40 litres of water a day, of this particular water, you had the equivalent of one 200 milliliter glass of milk. So really, there was no tangible benefit from consuming the product whatsoever, but it was marketed purely on the basis of its calcium-giving properties. So anyway, the idea was that things like this would be outlawed by the introduction of the nutrition and health claims. And it shows as well, I think, the way in which the nutrition and health claims regulation was introduced, something about lobbying. Because when this regulation was first proposed, the idea was you should never be able to carry a nutrition or a health claim if there was something about the product that was very detrimental to health. So for example, if it was really high in fat, you shouldn't be able to carry a claim that it was really good source of vitamin C or something like that. But that all changed. And by the end, when the regulation is introduced, they developed something known as nutrient profiling. And nutrient profiling means that even where it is very high in fat or sugar or salt or whatever, if it's only high in one of these things, well then you can still carry the nutrition or health claim. So certainly what was originally proposed has been diluted to some effect through the legislative process. And we see that as well in relation to the next piece of legislation, this new food information regulation. So we have a new regulation which was published on the 25th of October 2011. I'm not particularly good with dates, but that's my birthday, so I remember it. But this new regulation will introduce some new labelling requirements into the EU. It sets, for example, minimum font sizes, which were originally set at 3 millimeters, which, as the lobbyists correctly pointed out, meant that most of the type on food products was going to be much bigger than the print in newspapers. So that at least has changed, and it's been brought down to 1.2 millimetres, subject to you having enough space on the label to put on letters of that particular height. But I suppose the two big initiatives introduced by this new food information regulation, and it's called that because now it relates to things like e-commerce and selling things on the internet and advertising things on the internet as well. So it's not just a labelling-based piece of legislation. And the two main developments are that there are now more stringent requirements in relation to origin labelling, which has always been a problem. And to give a good example of how it's a problem, how many people could tell the difference between smoked Irish salmon and Irish smoked salmon? There's a huge difference. Irish smoked salmon, by its title, tells you that it's not Irish. It could be Alaskan, it's usually Scottish. It has been smoked in Ireland and nothing else. But smoked Irish salmon is at least Irish salmon, but has been smoked somewhere else, or possibly in Ireland. But the consumer doesn't necessarily know this difference between the two. Okay? So not only was origin labelling not required, it was only required where it might mislead the consumer, but I would have thought that was a prime example of misleading the consumer. But they would say, no, that's semantics, we won't worry about that. The only origin marking that has to be put on a product is where it either might mislead or it relates to certain meat products. So things like meat from sheep, poultry, and pig meat now all have to carry origin labelling. Beef has had to for some time since the BSE crisis of the 1990s. So we do at least have some new requirements in this regard. Having said that, as things stand as well, you could have a ready meal, for example, which is marketed as being Irish or French or whatever, and it could be made with 55, 60% chicken, and the chicken could come from Thailand, but it's still marketed as an Irish product. So there's no control really over that just yet. But there are hopes that that will change, and there is an undertaking to review that at a later stage. The second key initiative introduced by this regulation, although it won't actually come into effect until 2016, is that nutrition labelling is going to be compulsory for the first time. Now, while this is potentially progress, it's not definitive progress. In particular, for example, despite a wealth of scientific evidence showing the dangers of substances like the consumption of high levels of trans fats, some EU member states have banned trans fats. That's completely contrary to EU law, yet despite that, the European Commission has dropped proceedings against those states who banned trans fats in light of the overwhelming evidence of how bad for your health they can actually be. So what we have here is new nutrition labelling, nutrition labelling being made compulsory for everything, but in reality, practically every product carried it anyway. So the legal change isn't going to make a huge change to the real situation as it exists at present. But I just want to pause on this issue just for a minute or two, because I think it shows, and it's going to link a few of the things I've mentioned already together. And it's to do with the fact that we have a problem with obesity in the EU at present, and it's an ever-increasing problem. And it's shown to lead to other health issues relating to cardiovascular disease, the development of diabetes, cancer, strokes. One of the problems I've mentioned here already, and that is that states can't take their own action on the basis that it's necessary for health, where it's designed to promote nutritional value or nutritional benefit. The second thing is, and this relates back to Cassis, because of this principle of mutual recognition, member states can't introduce their own initiatives that require producers to give information to consumers, because to do so would be contrary to EU law and would be a blatant breach of EU law. Yet some EU member states have tried to introduce their own alternative labelling schemes to address the issues within their own states. Now, obviously, something like obesity, it's a problem that is created on three fronts. It can be to do with physical activity, it can be to do with genetics, or it can be to do with food. But at least on the food front, there is the potential for the law to intervene, to inform consumers properly so that they can make healthier choices. On the one hand, you have the possibility of doing something like banning trans fats. But the argument, of course, would be that that's far too interventionist. You've got to leave people to have a free choice, to make up their own mind in relation to these things, and there's no harm with the odd bag of Doritos. But on the other hand then, okay, well, what can the law do? Well, in states like the US, Canada, Switzerland, it can require that things like trans fats are labelled. But what some member states have tried to do is propose, I don't know to what extent, maybe you'll inform me in relation to this type of labelling appears on products in this part of the world. Has anyone seen this before? Okay. So we have these signpost or traffic light labelling schemes in the EU as well. The UK in 2006 published a white paper on public health. And one of the key initiatives that they proposed in the white paper on public health was the development of one of these signpost labelling schemes to clearly and quickly indicate to consumers where products contain high levels of things that they might like to avoid. Because of EU rules on free movement, they were not allowed to make this scheme anything other than voluntary. So nobody could be obliged to use it. The Food Standards Agency in the UK develops a template, and this is the template, which it hopes others will follow. Between March and July of 2006, March is the date of publication, by July of that year, 14 different signpost labelling schemes existed in the UK. No two of which were the same, and none of which were the same as the Food Standards Agency template. So the thing that was designed to introduce clarity was instead leading to more confusion. Producers and retailers were being selective about the ways in which they presented the information. It was also up to them as to how they calculated the information. While the Food Standards Agency said, look, you can only use green if it's something that can be defined as low sugar, low fat, as set out in the Nutrition and Health Claims Regulation. The problem is that while the regulation defines things that are low, it doesn't define things that are medium or high. So the things that are medium or high are left entirely up to the producers and retailers. And an awful lot of the time when something is high, it's just actually left off altogether. So you see in a lot of products, for example, they'll give you the fact that it's got no fat, like if it's in relation to something like Coca-Cola, but they won't give you anything else. Okay, so you'll just get that one piece of information that they're very proud of and not the other stuff. Now, why is all of this a problem? Well, the European Commission is, I suppose, sort of like, for those who aren't familiar with it, it's like the bureaucracy of the European Union. And it's divided up into departments, like you'd have a department for health, department for consumer protection, etc. Although they're actually both together in what's called DG Sanco, okay, taking from the French for health and consumers. Now, DG Sanco is the Commission department with responsibility for dealing with matters like food labelling and consumer protection. And their progress report on their own obesity white paper, which was published in 2007, found that on an examination of 7 member states, between 53.5 and 68.5 of men were either overweight or obese, and the 26% in brackets represents those who were defined as obese. Now, I actually have a problem with the way in which they define obese at present, but that's another matter. I think it was Michael Phelps was actually defined as obese at one stage, based on body mass index. Of women, it was between 47.2 and 61.8%, with 30% being defined as obese. Okay? And the figures were rising in 6 of the 7 member states that they examined. So the only member state, despite the introduction of a strategy to deal with this in 2007, the only member state out of the 7 was Finland, with their figures were improving. The World Health Organization has chipped in as well, and their European Childhood Survey has found that 24% of 6 to 9-year-olds are overweight or obese. And there's all sorts of economic data as well, which shows how it leads to so many lost working days, such an economic detriment to the economy, both in relation to production levels and also then obviously in relation to national health services. Okay, so we have clear scientific evidence which shows links between the consumption of saturated fats, trans fats, and things like fructose. And the argument is look, legal intervention is required to deal with these issues. Either you can introduce a ban, like some states have tried to do, or you can introduce taxes, like Denmark did. They introduced what was called the fat tax. And actually, they just abandoned it a couple of months ago because it was working so badly. What happened was an awful lot of Danish consumers were driving over the border into Germany every couple of months to stock up on things like cheese and other things that were subject to this high rate of tax. And what they also found was that Danish consumers were starting to consume lower quality versions of things like cheese than they had been previously, which had substitutes in them which had replaced the fats, which were actually far worse for you altogether. So it was found that imposing additional taxes doesn't work. You can work that the other way around as well, though. So, for example, in the UK, it's been proposed that you give VAT, or value-added tax incentives, to healthier products, and you reduce the taxes on those to create a carrot rather than a stick approach. But aside from that, okay, we have this potential to introduce these labelling requirements. The World Health Organization's Action Plan for Europe has specifically stated that because of the rate of the problem in the EU, adequate and suitable labelling for food products designed to improve their understanding is now required. The EU member states have tried to make their own efforts, like that in the UK in 2006, which was completely unenforceable. There was no obligation to follow the template, so nobody did. And despite this, the Department of Health in the UK has come up with a new proposal in 2012, launched with bells and whistles to create a clear and consistent labelling system across all retailers, allowing consumers to make quick, informed decisions to make healthier choices that address serious health consequences of poor diet, including obesity, cardiovascular disease, cancer, and diabetes. A couple of things to note about this. The first one is, obviously, it's still entirely voluntary, cannot be enforceable in any way. And secondly, and this is deliberate, it only relates to retailers. But of the 14 schemes that I mentioned being developed in the 4 months after the Food Standards Agency first launched its scheme, half of them were developed by producers and half by retailers. But they're only limiting it to retailers here. I imagine because they think it's the only thing they can exert any sort of control in relation to a voluntary code on, because producers will be coming in from all of the other member states as well. Okay. So just the previous point then illustrates, I think, because of the way EU rules on free movement have developed, they prevent member states from taking meaningful interventionist action to deal with health problems as and when they arise, in one of the only ways, and what has been set out in lots of policy documents as being the best way that the law could intervene to help to deal with that. But just looking at a couple of the other issues here in relation to EU food law more generally. There has been a huge emphasis on safety, perhaps to the detriment of other things in recent years in the EU, mostly arising out of the BSE crisis, which took place primarily in the UK in the mid to late 1990s. And the big problem with the BSE crisis was not necessarily BSE itself, devastating and all as it was, but it led to a huge confidence crisis amongst consumers because the law was shown to be so inadequate in dealing with a crisis like BSE when it arose. They were constantly trying to play catch-up with the disease as their knowledge of it developed. They made all sorts of declarations about how there was no link between variant CJD, the human form of it, and BSE in cattle. And by the time it came out to this declaration, or the evidence which showed that there probably was a link between the two, it was too late. The confidence was all gone amongst consumers. There had been lots of laws introduced, and none of them had done anything to really protect them. So in the year 2000, we have the publication of a Commission white paper on food safety. And it's completely transformed the way in which EU law has developed ever since. It led to the introduction in 2002 of something called the General Food Law Regulation. And this sets out a series of broad principles that apply across all food laws across the board now. So any new food laws that are introduced adhere to these principles. And these include things like the introduction of rapid alert systems, whereby if a crisis like BSE happens again in the future, well, we have points of contact, we can let everyone know at the first available opportunity, and we can then initiate what are called safeguard measures, which are designed to recall products off the market as quickly as possible, get the information out to consumers as quickly as possible that they need to stop consuming these things. It also led to the establishment of the European Food Safety Authority, which now has its headquarters in Parma in Italy. And the European Food Safety Authority provides a point of contact in relation to analysis of the science related to all food safety matters. So even where new labelling initiatives are to be introduced, the European Food Safety Authority is called in to give its opinion on all of these things. Now, what we really have in the EU at the moment is an atmosphere of precaution. Everything works now very much on a precautionary basis. I'll give an example from my own country. About 3 years ago, about a week before Christmas, and I know Turkey obviously is big here at Thanksgiving and that. In Ireland, it's very much turkey and ham. There was an announcement about a week before Christmas, the big period for pork sellers in Ireland, that Irish pork was contaminated with toxic substances. And immediately there was panic. All of the pork was withdrawn from the market. They estimated it cost around 200 million euros to deal with the crisis, even though the crisis was effectively over the next day. And the reason why it was over the next day was because there was such an overreaction to what had happened in the first place. It was demonstrated by the European Food Safety Authority's own data on this, that even if you consumed at the maximum level of toxicity, 3 times a day, every day, for 90 days, there was still no potential harm to your health. And that maximum level was 160 times more than the maximum permitted level. So what we've ended up with is a situation where these maximum permitted levels are set extremely low, at a level really that there's never going to be any potential danger to health. But there can be huge ramifications when you hear things like 160 times above the permitted level. Somebody else described it as being like 2 drops of water in an Olympic-sized swimming pool. So really there was no health concern whatsoever. In Ireland as well, in the past couple of weeks, it must sound like we've got a terrible food control system. We don't actually. It's because the system's so good that we end up identifying all of these problems. But recently, in the last couple of weeks, that you may or may not have seen it on the news, they discovered that Irish beef burgers contained horse meat. And I mean, in some cases, actually, the levels of horse meat found in the burgers were probably, through the tests that they conducted, just passed through the air in a factory where there was also horse meat being treated. In other circumstances, though, it was as high as 70%. Now, it turns out we were importing pallet loads of a frozen meat filler from other member states, I'm going to blame everyone else, which contained horse meat. But again, there was, there's something in burgers that there shouldn't be, get them off the market as quickly as possible. Given some of the rubbish that ends up in these burgers that are sold, at 20 for €2, horse meat is the last thing they should probably be worrying about. Anyway, so we have this general food law regulation, and we have this certainly atmosphere of safety in the EU. I think part of the problem as well is that the European Commission always sees safety and quality as being the same thing, and they're not. They're 2 very different things. Some foods that are deemed to be unsafe, for example, are usually of the best quality, like cheeses made from unpasteurized milk. There's a movement now to ban these cheeses in European Union member states, but obviously states like France and Italy are digging their heels in relation to this. They've never caused harm to anybody, but blanket ban, pasteurization, gone. Just to bring it forward then, and I'm probably running out of time here, so I'll get to move on with this, okay? But just to look at GMOs just for a minute. And I really want to look at GMOs more from the example of not good regulatory practice, but bad. The EU has a reputation for being quite cautious in relation to GMOs. But historically, actually, that's not the case at all. The only reason we have all these regulations and directives now controlling genetic modification is because they had such poor regulations prior to this. In particular, in the aftermath of the research from the University of Aberdeen, which showed that feeding genetically modified potatoes to lab rats was having detrimental consequences for their intestines. Initially, we had two directives. And I've only stuck all this up together because it's technical stuff. And it's just to show there was loads of stuff going on and none of it did anything. We had two directives at the start. The problem was that these directives didn't oblige you to state on the label where your product contained GMOs. We then had a regulation introduced in 1997 called the Novel Foods Regulation. When you bring those first two directives from 1990 and the 1997 regulation together, you found that two of the most commonly modified products, soya and maize, didn't have to be labelled at all. Okay, a loophole was created by the combination of these three pieces of legislation. So in order to deal with this problem, they introduced another regulation in 1997. But this regulation was very unclear and didn't make it clear in what circumstances genetically modified soya or maize would have to be labelled as such at all. So then they introduced another regulation to deal with this, in particular because member states, because of consumer pressure, were starting to take their own action and ban GMOs. So we had another regulation introduced in 1998, and it said you have to state on the label, clearly on the front of the package, where your product contains genetically modified soy or maize. So you think, okay, they've got a clear requirement at last. The problem was that this only applied to those products which don't have to have a list of ingredients. Because where they do have to have a list of ingredients, you only had to state it in the ingredients itself. Now, those products that don't have to carry a list of ingredients are a very limited group, and they include, for obvious reasons, things with no ingredients. Single ingredient products are the biggest group of things that don't have to carry ingredients. Some dairy products and carbonated waters. And these were all things that were highly unlikely to ever contain GM soy or maize. So the only things, even after these 5 pieces of legislation, that actually had to state clearly on the label that they contained GM soy or maize were those things that were highly unlikely to ever contain GM soy or maize. Otherwise, it just had to appear in the ingredients list. I had an interesting conversation with Larry beforehand about how they've changed it. What is it, transgenics now? They're called transgenics, they're calling it, okay. And this is because they feel that in Monsanto they maybe put people off by calling it genetically modified. And I've seen people look in shock when they're reading a list of ingredients and it says X, Y, Z, modified maize starch, ABC. And they say, oh great, it doesn't contain any genetically modified substances. But it does, they've just removed the word genetically. And I think once you remove that word, it becomes less scary. So there are ways around it. So even now where you do have to include it in the list of ingredients, you just call it modified rather than genetically modified, and people are completely unfamiliar with what it is that you're talking about. So the member states started taking their own actions. They weren't happy with this situation whatsoever. As a result, we ended up with a couple of things happening. Consumers were still concerned. They introduced an unofficial moratorium on the approval of all new EU GMO products. This led to problems within the World Trade Organization. Particularly the US and Canada had a problem with the fact that essentially this was contrary to international trade law. And we ended up with the introduction of a new directive and 2 new regulations. Now, the new directive and 2 new regulations are clearer, except for some confusing reason, and I still haven't worked it out, and I can never explain it properly. All 3 of these pieces of legislation set labelling requirements. There's 2 regulations, one on labelling and one on traceability. And then there's a directive as well. And there's still the Novel Foods Regulation too. And all 4 of them have their own individual labelling requirements. And all 4 apply. So rather than just have one consolidated text, they've ended up with this rather confusing situation. And there is still a lot of skepticism around genetic modification within the European Union. There's no question about that. But there was a far more alarming study published in France at the end of 2012 about the effects that genetically modified foods were having on lab rats again. And they were shown to grow tumours much more quickly than those which had been fed a non-modified diet. But there's been no unrest about this whatsoever. It's not getting the same sort of publicity as it did when there was these publications in Aberdeen 10 years before that. We had headlines in newspapers of things like Frankenstein foods, campaigns against it, all sorts of things like that. But it hasn't happened this time around for some reason. People have moved on to the next issue, which at the moment is horse meat. I just want to make a few concluding remarks then before I finish up here. The first thing to note is that, look, EU membership has had a really significant impact on the member states, both in relation to the fact that it has led to them all having a much more developed set of food laws, which they wouldn't have otherwise had, because most EU member states had a very undeveloped set of food laws before they became member states. But now, for competition and free movement of goods purposes, we have all these harmonised regulations and directives. But then it's also impacted the other way around as well. Member states are prevented, as we saw, for example, in relation to the nutrition labelling point, they're prevented from taking their own action where they feel it might be necessary to protect the health of their population. In particular, because the Court of Justice says nutrition is not a health issue. We also now, of course, have to take all of our international considerations into account as well. And the main international considerations are obviously those within the World Trade Organization. I've mentioned the one already in relation to genetic modification, where there was a dispute. There was also a dispute which led to an overhaul of the EU system for the protected geographical names that I mentioned. 2 new regulations had to be introduced in that area in 2006, because effectively the 1992 version of the system, the original version, closed it off to applicants or objectors from third countries. So if you weren't an EU member state, you couldn't access the system. And that was also found to be contrary to World Trade Organization rules. There's the Codex Alimentarius Commission as well. The Codex Alimentarius Commission, I'm not sure how familiar you are with it, but this is a United Nations organization run jointly by the World Health Organization and the Food and Agriculture Organization. And it sets international standards and guidelines which should, where possible, be followed. There's actually an important link between the first two there, because if you can satisfy the Codex requirements, a lot of the time it's a good way of demonstrating that you satisfy your World Trade Organization obligations as well. But the Codex has got an impact, not just on EU food laws, but on food laws in other jurisdictions as well. The US rules, for example, on trans fat labelling are almost identical to the Codex guidelines in this regard. And the two operate as a model for each other. And the European Union courts have used Codex guidelines to help them deal with legal problems as they've come before them. There was a case, for example, where the French authorities wanted deep frozen yogurt producers to relabel it as deep frozen fermented milk. Their argument being that, oh, you can't have frozen yogurt, it's a different product now. So they looked at Codex standards. The Codex standards said the key characteristic of yogurt is the presence of live bacteria in large quantities. Are they still in large quantities in the deep frozen version? Slightly less, but still abundant. Therefore, you can't impose a rule like calling the product deep frozen fermented milk instead. Okay, and then, so there's a relationship between the Codex and the EU laws. They feed off each other, they reflect each other a lot of the time. And as well, if the EU can show that its standards are in compliance with the Codex standards, then they can show they're also in compliance with their World Trade Organization obligations. And the World Health Organization, while it doesn't have any binding role in relation to the way in which EU laws develop, it does at least have a persuasive role to play. And when they say certain things should happen, well then the hope is that legislation will develop in that particular way. Like, for example, in relation to what they've said on nutrition labelling, but obviously that hasn't happened yet. Just finally then to note in relation to a few points here, because I mentioned in my title, and this is what I told Larry, so it's my fault and not his, that it was going to be about EU food law, the protection of humans, animals and the environment. And I haven't mentioned animals at all. I completely forgot about animals when I was doing it. It might have something to do with the fact that for the 10 days prior to coming here, I was battling a family of rats in my attic. So my sympathies for animals have diminished significantly over the past couple of weeks. They're finally gone, thankfully. It was a horrible experience. But there are various provisions in the Treaty on European Union which state specifically that EU law and policy must take account of consumer protection, of health protection, and environmental protection. In the preambles to all of our secondary legislation, it often says this legislation is introduced to protect consumers, to protect health, to protect the environment. The European Court of Justice, in its own deliberation, says this directive or this regulation was introduced to protect humans, the environment, or consumer protection. Yet despite all of this, what they always say, and this brings it back to the very first point that I made in relation to cassis, we must always, from a legal perspective, consider our protection of consumers' health and the environment in a free movement context. And that's always what they do. They say, yes, of course, it's legitimate to protect consumers, but it's more important that we promote free movement. And as a result of that, a lot of the time, you end up with situations developing like the fact that nutrition, while recognised to be important, is not significant enough to assist member states in doing things that are contrary to their free movement of goods obligations. And it's quite clear that whenever there's any dispute between free movement on the one hand and consumer protection on the other, free movement always prevails. And as well as that, just one final point to make at this stage, there has always been as well, in particular post-BSE, an overemphasis on safety, to the detriment of other things, in particular things like quality and nutrition levels, which have tended to be ignored more and more in recent years. Thank you very much.
All that water's for you. Thank you very much. So while our speaker consumes those 3 bottles of water over there, we are going to take some questions now. We would like you, because we're recording this program for use in the classroom, you can ask your own question, but we're going to run around with the microphone, and the speaker is going to stay here close to the podium and use this microphone. So if you want to ask your own question, just raise your hand, and we will bring the microphone to you. Or if you want to write your question down and have one of us read the question, I've got a few of them already, you can do that as well. Just let us know that you have the piece of paper. Thank you. Is this microphone okay? All right. So if you have your fill of water, you get to be over there. So who has the first question? Anybody? Dave. You want me to ask it for you? Yep. Wow. Dave has the first question. His question is, how does the EU system compare with the US system of food labeling, food safety, that sort of thing?
Okay. Part of my presentation for tomorrow morning is clearly a requirement here, and which I think is a very useful and productive point, is in relation to the fact that certain exemptions are given for small-scale producers and those who don't have a large turnover. I think that's an absolutely brilliant idea. We have a real problem now in the European Union because they introduce these blanket rules. And this means, for example, my local butcher was complaining recently that if he has a beef stir-fry and he sells it from the counter, packages it up and hands it over, he doesn't have to adhere to any labelling requirements because the food is not pre-packaged. As soon as he puts it in a foil tray and puts a bit of cling film over the top, he now has to put a list of ingredients on the product. And from 2016, he's going to have a nutrition declaration as well. Now, that nutrition declaration is going to oblige him to have laboratorily tested the constituents of the food. So it just won't be possible for him as an independent, standalone butcher to pre-package any of his products anymore. It's just not going to be possible for him to do it. The person who makes jams and sells them at the local farmer's market has to adhere to the labelling requirements as well. When they introduced the Nutrition and Health Claims Regulation in 2006, it applied in the same way to the small business as it did to the large one. So it's much easier for the large firm to make a nutrition and health declaration because they have the financial backing to get the scientific verification required to be able to make the claim in the first place. So while I see certainly some value in things like the trans fat labelling, in a more general sense, I see real value in the exemption for small-scale producers. I think it's a wonderful idea, and it's something that certainly I would be advocating in the future. And it's something I wasn't aware of till relatively recently, but I think it's the way to make the system work and work fairly.
I was curious about the geographical names protection laws.
Sure.
And how comprehensive those are. For example, can those areas import raw materials from other regions and just produce them there? How comprehensive are those protections?
Okay. Well, I suppose they're comprehensive in two ways. First of all, there are a lot more of them than there used to be. So it's becoming a very popular system to use. So for example, in the likes of Spain, France, and Italy, they all have between 200 and 300 of these names registered each. In Ireland, we have 4, and we're applying for a 5th. A product beautifully named Blah, which is a type of bread. But so we've 4 at the moment in Ireland. But so it's being used more extensively. In particular, there's a recognition of the value of placing the symbol on the product, because it's now a clear way for the consumer to identify that there's a link between the product and quality. That's the first thing. In relation to the rules themselves, you've got 2 different classifications: your designation of origin and your geographical indication. For a designation of origin, everything has to happen in the original place of production, and that place has to be defined as part of your application. And no production can take place, and none of the materials can come from outside of that defined geographical area. Every part of it has to happen in that area. With the geographical indication, that's not the case. It's only one or more parts of the process has to take place in the area. Now, while on the one hand, obviously, that's an easier thing to satisfy, it's also a more difficult thing to satisfy, because it's harder then to make the link between the locality and the characteristics if the raw materials are not from the locality. And interestingly, despite the fact that in some ways it's easier to get geographical indication status than designation of origin status, the level of legal protection for both is identical. Okay, they're defined differently, but the protection available is exactly the same. Okay.
Kind of on that same topic, is there any way to control producers outside the EU who are using those names, or how does that work?
Okay, that's a great question. There is, to a degree, a way of controlling them, but it's within the World Trade Organization structure. Articles 22 to 24 of something called the TRIPS Agreement, or to give it its full title, the Agreement on Trade-Related Aspects of Intellectual Property Rights, sets out rules for geographical indications. Now, the problem with this is this is a relatively new area that is being dealt with by the World Trade Organization. I mean, the organization itself has only existed since 1995, and it never dealt with this at all prior to that. So it's still, I suppose, in some ways in its infant years, although it's nearly 20 years at this stage. But what they're trying to do is negotiate at international level a series of reciprocal arrangements, whereby we will protect X if you will protect Y. So as things stand, it's very much on a case-by-case basis. So there's no fully enforceable international legal mechanism at present, but they're working towards it. In general terms, the legal basis exists within the TRIPS agreements, but in practical terms, it's not yet fully applied.
Okay, I got a question here written down, and I know who wrote the question, so you're going to correct me if I get this wrong, but I think the question is something like this. Do nations have control over the food markets that, under what circumstances can they override the EU system of trade, of food labeling, food standards?
They can't.
If any? They cannot?
They cannot. So, for example, right, if they wanted to set a requirement that you had to clearly indicate on the label, this is pre-compulsory nutrition labeling, clearly indicate on the label what percentage of your bread is made with salt. They couldn't enforce that. They could ask their own domestic producers to do it, but once the goods are being imported from another state, they have to be allowed to trade in the state in which they're being sold in the same way as they are treated in their own state. And that's this principle of mutual recognition. Once you can sell your product in one state, you have to be able to sell it in another. So in relation to free movement, they've no control over how they apply the laws. In relation to the laws specifically themselves, the food labelling laws, they are a harmonised standard, which means you must apply the laws as they appear in European legislation. Just to explain very briefly, there's a legal issue in relation to this. Up until now, all food labelling laws have been introduced into the European Union by way of what we call directive. Okay? And a directive is only to some degree legally enforceable at national level. But it does have something what we call direct effect, which gives it proper legal effect. But that's irrelevant now anyway, because they've decided instead to introduce what we call introduce the new labelling requirements by what we call a regulation. And the regulation is directly applicable, simultaneously, in full, in all member states. Not only should the member states not transfer it into their national law, they are prevented from transferring it into their national law. So the law applies exclusively as it appears in the regulation. So to answer your question in very simple terms then, they've none. Unless they can show it's necessary for some justifiable exception, like health protection, but that almost never happens.
So could we potentially, and you actually just happen to be in a state that is kind of on the forefront of, labeling and wanting to see ourselves as being the front runners of that movement. With that being said, could we, as a state, run into some of the same problems of national food coming in that are unregulated, finding loopholes? So essentially being able to, what we think is an accomplishment of labeling food, but national regulated international companies still importing food to our supermarkets and things like that, being able to find the loopholes without proper labeling, and essentially maybe hurting our local independent market in the process. So maybe labeling as a statewide and not a national-wide movement, almost damaging or hindering our sort of local.
Oh yeah, I see what you mean. Yeah, although I think it can work the other way as well. Like I've no real expertise on the way in which the American system works, but the way you can often view these things is actually you give yourself a competitive advantage by associating yourself with quality. So, for example, you don't give yourself a competitive advantage if you're more expensive, but if you're recognized as having a particular quality, then I think there's a willingness to pay a premium, which wouldn't exist if there was no familiarity with the quality issue.
Well, I think that this area is kind of unique to that, actually. I mean, I wouldn't say that would be feasible in a lot of other states, but given the strength of the local farm and produce, even in really just the Pacific Northwest in general, Washington, Oregon, myself taking kind of great pride in the local products. So I guess ultimately you see that staying on the forefront of that labeling movement in the state is more advantageous for us to kind of.
I think so. I think, for example, if we look at our own situation in Ireland as well, we're very proud, for example, of our beef industry. We've got some fantastic beef products in Ireland. And the point is that, look, consumers are actively, and the evidence all exists to show this, are actively avoiding the importation of, in particular, meat products from other states because they have no clear identification about the quality standards, there's no clear identification about the animal welfare standards, and as a consequence of that, people, and there's increasing evidence to show this, are shopping locally because they have a recognition and an attachment to both their place and a loyalty to their place, but also to the quality that it represents. So I definitely think that there's.
So even almost as a leveraging effect to products coming into the state, having to adhere to more competition based on our strengthening local market.
Sorry, could you repeat that?
So it could almost help us leverage even products that are coming in to make sure that they're labeled, also start ultimately lowering the cost of products coming in with the strengthening of our own local market, adding more national companies competing to put food on the grocery store shelves just based on our strength of the local.
Yeah, no, I think so. I think that the quality issue is huge and gives a huge advantage. Okay, thanks.
What's the experience with a country like China, exporting or importing?
In what sense?
Do they have an equivalent system? And
China.
How good is it?
China remains outside of a similar sort of system to the one we have at present. I was involved, actually, just while you mentioned China, in a very interesting case last year. I'm not a practicing lawyer at all, but just to give you an idea of how, I mean, the EU, for example, is very protectionist at a trade level in relation to goods coming in from China. I was involved in a case last year. I was called in. I've never been in practice. I never wanted to be in practice. I value my work-life balance too much. But I was called in as knowing something about food law for this guy who was being charged with importing garlic from China. And he had avoided paying duty on it by calling it apples. But there was a very good reason for calling it apples. Apples that are imported from outside the EU come in at a tariff of usually around 9.6%. It depends on the time of the year. When they're in season in Europe, the tariff goes up slightly. Garlic being imported from China can be subject to duties of as high as 232%, because they're subject to a 9.6% charge plus 120 euros per tonne, which, depending on the price of garlic, can equate to 232%. Anyway, he avoided tax in the region of 1.6 million euros by calling it apples. And as a consequence, got a prison sentence of 6 years. And he's currently serving a 6-year prison sentence. And it's been back before the courts, actually, 3 times already in relation to an appeal on his sentence, because it was the most severe tax evasion penalty ever handed down in the history of our state. So actually, being familiar with and adhering to the importation laws from other member states, as you can see, can have very meaningful consequences for individuals, both in a financial sense and also obviously in relation to his freedom. And what's interesting about it is, and just shows you how strange the way these things work sometimes, is chilled garlic could be subject to this 232% rate, but if he had called it frozen garlic, it would have only been subject to the 9.6%. So this minor difference, I know there's a difference between the products, but it's a less blatant avoidance of the law if you call something frozen garlic rather than called apples, when in reality it's chilled garlic. Anyway, poor old Mr. Begley's still in prison.
Okay, another question written down here. In Europe, when food testing is done for labeling, it's required for labeling, is the testing done by third parties, or can it be done by the producer?
Okay, well, initially the producer would do it to be able to make the declarations that they make, but then obviously there has to be independent tests carried out as well. So, for example, a very good example of this would be in relation to the fact that they found this horse meat and beef burgers in Ireland recently, and that was because the Food Safety Authority of Ireland was conducting its own independent tests. And so what you have is you have a dual system, really. People make their own declarations, but by doing so are undertaking to adhere to the obligation that they ensure that those declarations are not misleading in any way or untruthful in any way. And then it's up to national competent authorities, like the food safety authorities, to independently test those. I have a PhD student at the moment who works in the dairy sector, and what he tells me about, obviously he has a different perspective on these things than I do because he's actually working in the sector, and he says some interesting things in particular about how labelling of dairy products can never be right, because you can't be that obvious or that truthful about dairy labelling. For example, if you've got full-fat milk and it's 4% fat, it might be 2% fat in the summer and it might be 6% fat in the winter, because it's different levels of fat at different times of the year, it's different cows, it's different herds, it's all being mixed together. So you can never actually get the labelling right on products like that. So I don't know what would happen in those circumstances when it comes to verification. Hopefully they don't come to the same fate as our garlic importer.
Another question submitted. Here, a little bit of background. Recently in New York City, the mayor put a limit on the portion sizes. You may have heard about that. And the question was, have there been any similar attempts to use labeling laws in Europe to limit portion sizes, in effect, like it's been done in New York City?
Yeah, no, not the same, not to the same degree, But there are certainly moves, and there's a lot of lobbying going on about nutrition declarations in restaurants. So that's what's happening. There's nothing on setting portion sizes at the moment, but there are efforts being made to make restaurants comply with the same labelling requirements as for pre-packaged products. Because as things stand, the legislation only applies specifically to pre-packaged foods, which obviously doesn't apply to restaurants. And some are already doing it voluntarily.
Any other questions? Well, then I think we should give our speaker a great round of applause.
Thank you very much. Thanks, Larry.
This is yours, right?
Oh, yeah, thanks.
Sorry. Oops. So, let me just, whoops, what did I do? Oh, it doesn't matter. Anyways, I hope you've all really enjoyed the program that we had here tonight. And again, we do welcome your feedback, so take a moment to give us on the piece of paper that's in your program, if you have any thoughts to share with us. We very much would like to see to get your feedback. We hope that you will be attending other events. This is the first event in a 4-part series, so please come back and participate in the later ones. But do note that next week, we will be meeting on Tuesday evening rather than Thursday, because Thursday is Valentine's Day. And at least I am still hoping that someone asks me out to dinner. I have a honey out there somewhere that might, but one can always hope. But please note that next week's meeting is on Tuesday rather than Thursday. And the list of the program, the events in this series, as well as other things that we have planned here, are in page 3 of that program, so take a look at that. If you'd like to receive notification of these events and you haven't been, please give us your email address, write it down there, and we will put you on our email mailing list and let you know what's going on. And with that, I'm going to say thank you for joining us tonight, and get home safe, and we hope that we see you again soon. Thank you.